Judgment in the appeal of the Child Poverty Action Group against the Secretary of State for Work and Pensions.
Lord Walker will give it. Sorry, beg your pardon, Lord Brown.
In about 2006, the Secretary of State adopted a practice of writing to social security benefit claimants who he considered to have been overpaid as a result of miscalculation of their award, indicating that his department had a common law right to recover the overpayment. We were told that although no claims have in fact been brought in court, these letters led to the recovery of substantial sums. The current appeal arises out of a test case brought by the Child Poverty Action Group on behalf of social security claimants to challenge the Secretary of State's claim to such a right of recovery. Both parties agree the Secretary of State is able to recover mistaken payments, for example, when a cheque for £120 is sent following an award of £60 as money paid by mistake. What is in dispute is the Secretary of State's right to demand overpayments made as a result of errors in calculating the award. Errors, that is, apart from those caused by the claimant's own misrepresentation or non-disclosure. This would arise, for example, where a claimant has notified a change in circumstances, such as that he has begun full-time work, and by mistake the department overlooks or delays actioning the notification and continues payment benefits at the same rate. The Secretary of State has a statutory right to recover overpayments caused by misrepresentation or non-disclosure of the benefit claimants. This right is currently set out in Section 71 of the Social Security Administration Act 1992, although it can be traced back to Section 20 of the Supplementary Benefits Act 1976 and Section 119 of the Social Security Act 1975. No other statutory provisions allow for the recovery of overpayments. However, the Secretary of State submits that his right to recover mistakenly inflated awards arises under the common law of restitution and thus cannot be excluded by statute save by express words or necessary implication. It's his case that Section 71 does not expressly or by necessary implication exclude this right. The High Court found in favour of the Secretary of State. The Court of Appeal unanimously allowed the Child Poverty Action Group's appeal and declared that a benefit falling within Section 71(11) of the Social Security Administration Act 1992 can only be reclaimed from the claimant under Section 71 of that Act. It is the unanimous view of this Court that the appeal should be dismissed. We would hold that Section 71 provides the only route to recovery of Social Security benefit overpayments to the exclusion of any common law rights. We agree with the respondent that rather than excluding any right to recover, Section 71 and its predecessors created a power of recovery when otherwise, because of the then existing division between the functions of adjudication and payment, there would have been none. We see no basis for holding that the merger of the adjudication and payment functions in 1998, not accompanied by any change in the statutory power of recovery of overpayments, was intended to widen the door to recovery. What is striking about Section 71 is not Parliament's omission of an express exclusion of common law rights, but rather its omission to include any provision for recovery of mistaken overpayments alongside provisions in respect of misrepresentation and non-disclosure.
Judgment in the appeal of Progress Property Company Limited against Moorgarth Group Limited.
Lord Walker.
A limited company not in liquidation cannot lawfully return capital to its shareholders except by way of a reduction of capital approved by the court. Profits may be paid to shareholders, normally by way of dividend, but only out of distributable profits. Whether a transaction amounts to an unlawful distribution of capital is a matter of substance, not form. It may consist of a dividend paid when a company has miscalculated its distributable profits. It may consist of a distribution of property disguised as an arm's length sale, or of cash disguised as properly earned remuneration. Occasionally, even today, it may consist of a dominant shareholder simply treating his company's property as his own. In this case, the transaction attacked as an unlawful distribution was the sale for about £63,000 by one company, PPC, of the shares in its subsidiary, YMS1. YMS1 owned, through its own subsidiary, YMS2, freehold shop premises let to another company, YMS, within the same group. YMS had entered into full repairing covenants, but had been unable to perform them. The sale to YMS1 was a preliminary to about 75% of the shares in PPC being sold outside the group, and the sale of YMS1 kept it, and so YMS2 and the freehold property within the group. The freehold property had been professionally valued at over £11 million, but it was mortgaged to a building society, and the liabilities of YMS1 amounted to nearly £8 million in all. Moreover, the valuation had, unusually, but no doubt on instructions, explicitly disregarded doubts as to the covenant strength of YMS and the state of repair of the property. There was therefore real doubt as to YMS1's true net asset value. The judge did not make any definitive finding as to the net asset value or as to the giving of indemnities or counter-indemnities in respect of the repairing liabilities, a point on which there was confused and conflicting evidence. The judge was satisfied that in any event, the directors involved in the negotiations believed themselves to be engaged in a genuine arm's-length sale. It could not therefore be an unlawful distribution of capital. The Court of Appeal unanimously upheld that decision. The Supreme Court also unanimously upholds it. In doing so, it holds that the characterization of a transaction as a distribution of capital does not depend on a wholly objective approach. If it did, a company which simply made a bad bargain with a shareholder, even though acting in good faith, might be open to attack. The court's task is to inquire into the true purpose and substance of the impugned transaction. This involves an investigation of all relevant facts, including, if there is an allegation of a disguised distribution, the parties' states of mind. The appeal is therefore dismissed.
Court will adjourn.